Hello, my name is Michael Tessera and I prepared this video case note and I've entitled it Lifting the Lid on the NQCranes case. And the reason I've called it that is because I think when you look at the case and understand a bit of the background, you can see that it's actually an unsatisfactory case given the fact that NQCranes weren't the prime mover in this particular cartel agreement. So I'll be looking at the case of ACCC and NQCranes in a bit of detail and explaining why I think there's some problems with it. A bit of background about myself. I'm a competition and consumer lawyer. I've been running my own practice to say legal consulting for the last 15 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years as well, and in that organisation, a variety of roles, including as director of enforcement, and I ran various cartel investigations and litigation. The outline of the presentation is pretty simple: background, decision, and then a bit of commentary. Now, the background to the case is ACCC took NQCranes to court alleging that they'd entered into an agreement which contained a cartel provision. And this was a distributorship agreement which was executed in August 2016, so it's quite a few years ago, with its competitor MHE DMAG. And this particular distributorship agreement contained a clause which was described as a coordinated approach provision, which is found to be a cartel provision. And relevantly, Clause 2 defined two specific territories. Firstly, Territory 1, the state of Queensland, excluding the area south of Gladstone, and then Territory 2, the state of Queensland, south of Gladstone and Newcastle. Now, the cartel provision was under Clause 3, and it stated for Territory 2 distributor, which is NQCranes, and MHE DMAG will operate in the service markets in a coordinated approach so that their current customers are not targeted by the other. For potential future customers, two organisations will ensure that their energies are focused on the other service competitors and not each other. So that's the clause that was found to be a cartel provision, and it clearly is a cartel provision. There's an agreement there not to target each other's customers, not to market and try to win them over from the competitor. The thing you also notice about this particular clause is the way it's drafted. It doesn't seem to have been drafted by lawyers. Some of the wording in there doesn't seem consistent with the way lawyers draft terms of agreements, particularly the reference there to energies are focused on the other service competitors. It doesn't sound like a lawyer was involved in drafting that. Now, NQCranes admitted that it had entered into a cartel provision, that the coordinated approach provision, which you just looked at, had the purpose of allocating customers between NQCranes and DMAG. Furthermore, that the coordinated approach provision was a cartel provision, which within the meaning of the Competition and Consumer Act, and furthermore that by entering into the distributorship agreement, NQCranes had made a contract which contained a cartel provision. So the thing to note there is there's no allegation that NQCranes or DMAG put this particular cartel provision into effect. That's a very significant thing to note. So the judge had to look at the various penalty factors, and the first factor was whether senior management of NQCranes were involved in the preparation of the cartel agreement, and the judge found that they were. Senior management team of NQCranes were involved in the negotiation and drafting of the agreements, so that obviously counted against them. The judge found that the contravening conduct was not deliberate in the sense that the senior managers were aware that the distributorship agreement contained a cartel provision, so they weren't deliberately flouting the law. They had no understanding of the relevant Competition and Consumer Act provisions. The judge also found that the conduct was isolated and not covert in the sense that it was written down. So the coordinated approach provision was written down in black and white in the agreement, so it wasn't covert in that sense. However, it was covert in the sense that the customers were unaware of the existence of the agreement to allocate customers between the two competitors. The judge also looked at the level of cooperation and found that they had meaningfully engaged with the ACCC, admittedly at a late stage in the proceedings, that they participated meaningfully in settlement discussions and participated in a court-ordered mediation, and that's where the agreement was arrived at to settle the case. Also, a factor that sort of assisted them was the fact that the distributorship distributorship agreement was entered into at a time when NQCranes had no competition law knowledge, training or compliance program, so it was ignorant of the law. And what also counted in their favour was the fact that once the ACCC commenced investigation, they took quick steps to implement a comprehensive compliance program. And then finally, the fact that NQCranes had not previously been found to have breached the Competition Consumer Act counted in their favour. Now, a very relevant factor to weigh up when determining on the relevant penalty is the size and nature of the business. And here you can see NQCranes is a family-run company based in Mackay. It has a number of branches, however, it has less than 100 employees, so it's a relatively small business. And it has recorded revenues, and in the judgment they had the revenues for 20 and 21. So in 20 they had a revenue of 26 million, and then in 21 it was 22 million. Surprising they used those particular years. You would have expected they would have used 2016, which is the year that the agreement was made. But as you can see, it's a relatively small business. But what's really relevant there is the profit levels, and as you can see that in 2020 they had a profit of $1 million, but in 2021 it dropped down to 95,000. So that's a very volatile market that they're competing in. Now the judge weighed up all the factors and concluded that it was an isolated event, that it had occurred for a limited time. It was a single contravention, and significantly there was no allegation that the agreement had been put into effect, so there wouldn't have been any detriment to any consumers from having been allocated to one of the other competitor. Clearly the senior management were involved, but they didn't understand the law. It was done out of ignorance. However, here she concludes that the conduct was deliberate in the sense that there was an intention to allocate customers to each other, and so that counted against them. Clearly it was intended by the agreement to allocate customers and to maintain their existing customer bases. So weighing up all the factors, the judge concluded that a penalty of $1 million was appropriate, believed that the seriousness of the contravention was such that there was obviously mitigating and aggravating factors, but that a $1 million penalty had a sufficient sting to ensure that NQCranes did not engage in breaches of this nature in the future, so specific deterrence. Implication there as well is that this penalty is sufficient to achieve general deterrence, to stop other companies from engaging in similar breaches of the law, that nobody would see $1 million as being an acceptable cost of business, and it was going to achieve the goal of deterrence both on a specific and general level. Now, just a bit of commentary here. The first thing that I think is really important about this case is that it was actually DMAG who proposed the coordinated approach provision to be included in distributorship agreements. So they were the prime mover who proposed this cartel provision, who it seems suggested the wording of it, and they're the group who it appears has blown the whistle on the cartel agreement, because there's been no proceedings commenced against DMAG, and they've got a full immunity. So you've got a situation where the prime mover, or the first company to actually think up the illegal conduct, has been able to get full immunity and not get taken to court by the ACCC. The other concerning aspect is DMAG is actually part of the NQCranes group, which is a global lifting company. It's a leader in the market and has an annual turnover of over 3 billion euros. So you have a company, massive company, who initiates a cartel agreement with a small family-owned company and ends up getting a full immunity and walking away, while the competitor gets taken to court and fined $1 million. So that's a very big concern, and I don't think that's really the way it should operate. The other factor is that the distributor agreement was entered into in August 2016, but it was never put into effect. So it's obviously been included in this agreement, but nobody's actually taken any steps to allocate customers between the two companies. And so it's caused absolutely no detriment to any consumers or any customers. So it seems to me that in those circumstances, $1 million penalty seems very large. Now, one thing to understand about the ACCC policy in relation to immunity is that you are able to obtain an immunity even if you are the prime mover in relation to a cartel, as long as you're not the party who coerced others to participate in the cartel. So that provision in the immunity policy gives the ACCC a lot of wiggle room to allow companies which have actually thought up the cartel provision and proposed it to the other competitors to actually get full immunity and walk away because they actually haven't pressured or coerced their competitor to enter an agreement. The other thing that I think is relevant is the maximum penalty for the conduct was $10 million, and that's because the 10% of turnover didn't apply in this particular case. And so the penalty that was imposed was 10% of the maximum. So $1 million is 10% of the maximum penalty that could have been imposed. But that is also 4.5% of the turnover for 2020. So when you're thinking about it, that's quite a high proportion of a small business's turnover. But what's probably more relevant here is that in 2020, the profit of NQCranes was $1 million. So this penalty is equivalent to the entire profits that the company made in 2020. But even more starkly, as you can recall from earlier, in 2021, their profit was $95,000. So this penalty of $1 million is actually 10 times the profit which they generated in 2021. So it seems to me a very large penalty, and I think the judge really should be looking at the turnover and the profits when determining the adequacy of the penalty. It's not good enough just to look at the maximum penalty of $10 million and then conclude that 10% of the maximum is appropriate. You really should be looking at all factors, the maximum, as well as the turnover, as well as the profits. So if you look at it in terms of this penalty being 10 times NQCranes profits from 2021, the penalty takes on a whole different perspective. And the other factor that's relevant here is 2016 is the year that the conduct actually occurred, and that really should have been the year of annual profits to be taken into consideration when looking at the penalty. And I don't know why that number wasn't used. Maybe that was more favourable to NQCranes. I suspect it probably wasn't. I would suggest that their profits and turnover in 2016 were probably lower than in 2021. So the final issue to note is that the laws have changed in relation to penalties under the Competition and Consumer Act, and they're much higher now. It's actually $50 million, 3 times the benefit, or 30% of the adjusted turnover. So in this particular case, if this case had been run now with the new provisions, the maximum penalty that the judge would have been looking at would have been $50 million for the make. So it would have been interesting to see what the judge would have thought of a proposed penalty of $1 million in the context of a maximum penalty of $50 million. So that's all I had about the case. I think it is a concern on a number of levels. It's clearly the case that the larger competitor proposed the cartel provision to NQCranes. Then they must have identified the existence of the cartel provision, maybe in the context of the merger that was being looked at by the ACCC a number of months ago, which was ultimately abandoned, involving NQCranes. And then they've gone and blown the whistle on their competitor and been able to walk away and escape any liability. And NQCranes, the smaller competitor, has been fined $1 million. And when you think about it, DMAG and NQCranes are a very large company. They should have known better. They should have had compliance systems in place to prevent such agreements from arising. Furthermore, I think $1 million penalty in a situation where an agreement has been made but not actually put into effect, and thus hasn't caused any customer detriment, should mean that the penalty was lower. So I think $1 million for a make where there's no detriment to any customers is really too high, particularly given the size of NQCranes. So that's all I had. If you have any questions about this particular presentation, feel free to give me a call or drop me an email. Bye bye.